Hi there, everyone. It's Rob Ryder. Hey, did you know that you cannot impeach an imposter? I think that'd be an impossibility. But maybe you can have them declared one. That and other uses of a declaratory judgment. That's the basis of this video, and they all go hand in hand with the last few videos I have done. Which did they did they serve? Then they deserve. Within which one of the things I was pointing out that as I had filed a claim against the American Legion for it not upholding its federal charter, and I filed it with the United States Court of Appeals for veterans claims. Turns out, hey, veterans, we have our own Court of Appeals, and they would make it seem like this is really just for things that have to do with the Secretary of Veterans Affairs. But that isn't really how it reads when you read it. And so you can, no matter what you do, you have to send a copy of it to the Secretary of Veterans Affairs, but you can have somebody else be the respondent. And so I made the American Legion the respondent. And lo and behold, they made it a court case and put it on the docket. I already had one on the docket to do with my disability. And so, I've got a lot of things going on here. Let's try to keep them straight. The one on the disability, I have a 10% disability, but I believe it doesn't really matter what the percentage of your disability is, that you should be able to claim unemployability, especially if you're not making $36,000 a year, because that's what they would pay you if you were considered 100% disabled or unemployable by the military. And they have this particular phrase they use to determine if you're employable or not. And I say, because of the phrase, the way it's written, that I am not able to acquire substantially gainful employment. Because to do that, I would have to be non-disabled by definition, and they said I have a disability. So a little bit more on that in just a second. But what came out of that was I had filed a motion for declaratory judgment into the case here just recently, like I think on Friday afternoon I put it in. And I think I put it into the wrong window, so I changed but I sent it to the wrong email address, basically. Changed the email address, and hey, it popped up today for a motion for declaratory judgment. And we'll look at it in just a second, but let's go back to, what the hell are we talking about? So there's a couple of federal laws that fall together. 28 U.S. Code, so USC 2201 and then 2202. But let's just read these real quick. So 28 U.S. Code 2201, creation of a remedy. Creation of remedy. In case of actual controversy within its jurisdiction, except with respect to federal taxes or other actions brought under Section 7428 of the Internal Revenue Code of 1986, a proceeding under some sections of Title 11, or any civil action invoking an anti-dumping or countervailing duty proceeding regardless of class, of kind, of merchandise, of free trade area. That's something to do with NAFTA, I think. As determined by the administering authority, right? So they're the ones who get to determine if your request falls within those boundaries or not. So any court of the United States, well, that would be the Court of Appeals for veterans claims. It would also be the court down the street, because it's a court of the United States. Right? So any court of the United States, upon the filing of an appropriate pleading, may declare the rights and other legal relations of an interested party seeking such declaration, whether or not further relief is or could be sought. Any such declaration shall have the force and effect of a final judgment or decree and shall be reviewable as such. For limitations on actions brought with respect to drug, not really caring about that, And then just really quick, 2201. Further relief. So further necessary and proper relief based on a declaratory judgment or decree may be granted after reasonable notice and hearing, show cause, against any adverse party whose rights have been determined by such judgment. Hey, I'm Rob Ryder. My email address is courtofrecord@aol.com. Phone number is 616-712-6179. If you could donate, please do. You can call it charity. It's okay with me. My PayPal account name is Rob Ryder at AOL.com. That's ROBBRYDER at AOL.com. You could send me an email and ask for a PayPal money request, in which I would send you something through PayPal for whatever amount of money you had requested that I ask you for a donation of. Or there's always Western Union or Walmart. But if you use those, you really need to make sure you get my name right. It causes lots of problems when they don't have my name right, they don't have your name right, and so forth and so on. So be precise. So my name is Robert Allen Retluski. That's RYTLEWSKI. At 10955 14 Mile Road Northeast, Rockford, Michigan 49341-8664. You could send me a check to that their address. Okay, so what are we doing? Well, the way this thing reads, if you can get them to agree with you, they can declare that you're right and give you whatever you ask for without going through the whole rest of a court case. You just put the pleading in and ask for a declaratory judgment. And this is federal law, right, which this said courts of the United States, but I was looking at, I'm helping some guy in his foreclosure. He's in Alabama, and sure enough, in Alabama, they got a section on declaratory judgments. Purpose and construction, administration of this article. This article is declared to be remedial, right? For a remedy, its purpose is to settle and to afford relief from uncertainty and insecurity with respects to rights, status, and other legal relationships, and is to be liberally construed and administered. This article shall be so interpreted and construed as to effectuate its general purpose, to make uniform the law of those states which enact it, and to harmonize as much as possible with federal laws and regulations on the subject of declaratory judgments. Well, we just read what the federal government had to say. And Alabama saying, hey, we agree. Whatever the feds say, that's what we're doing. So, powers of courts of record. Courts of record within the respective jurisdiction shall have power to declare rights, status, and other legal relationships, whether or not further relief is or could be claimed. That just sounds like it came out of the federal law. No action or proceeding shall be open to objection on the ground that the declaratory judgment is requested. No action or proceeding shall be open to objection on the ground that a declaratory judgment is requested. So ask for it. The declaration may be either affirmative or negative in form and effect, and such declaration shall have the force and effect of a final judgment. That really sounds like the way to go, doesn't it? So here's why I was looking at it, because it's for construction and validity of instruments, statutes, ordinances, contracts, or franchises. Any person interested under a deed, will, or written contract, that would be your purchase agreement to your real estate, or other writings constituting a contract, or whose rights, status, or other legal relationships are affected by statute, municipal ordinance, contract, or franchise, may have determined any question of construction or validity arising under the instrument, statute, ordinance, contract, or franchise, and obtain a declaration of rights, status, and other legal relations thereunder. We really got to figure out how to do this. This would solve so many problems. If you could just take them to your buy-sell agreement, better yet, have your buy-sell agreement for your real estate and your appraisal from an appraiser is a state officer, got a state license. And he had to appraise it for you to get the loan in the first place. And so that was the appraisal information is what the lender was supposed to use to make you a loan. And so on that document, I should go find one real quick. So I'm going to hang on just a second. Be right back. Okay, so I was going to go find this form for an appraisal, but just real quick, so they have like an update form. If you already had an appraisal, they can come and do an update, right? That's one way to have it done. There's also a restricted use style of appraisal, and there's a uniform residential appraisal report. And as it turns out, that appraisers are, they're expert witnesses, get called into court. They do these restricted use style of appraisals for divorces, right, to determine the value of the property. But they also do this thing called the Uniform Residential Appraisal Report, which would have been for the lender in your real estate transaction. And it shows the property address, who the borrower is, right? What the owner of public record is, or who it is, what the legal description is, what the assessor's parcel number is, neighborhood name, occupant. So I've covered this before in another video. I'm not going to go through it all again. But my point is, right, this is a state officer doing this. So I'm going to say, well, whatever he says is what the property is. Well, this isn't the same information that they would be using in a foreclosure. I mean, this guy don't have much room for a legal description. So unless he's going to say see attached and use the same thing they're using in your foreclosure, chances are they're different. Chances are the borrower's name is different than the borrower's name is on the deed of trust or some other document. Chances are these aren't going to match. Just as soon as somebody sends me one that they've had done, I'll know for sure. But let's say you already own your house, right? You'd still may want to have an appraisal done because you want to see what the owner of the public record is. Whose name is here today? If you're the owner, then your name will be as the owner of public record. And over here, you'd be over here clicked as the owner if you're, living there with fee simple property rights. And if it isn't that way, then there's something wrong in the records. And I believe the appraiser is the one that can find the records to get them fixed, right? Map reference. That's going to tell you what survey map you're on. Because a map is really, it isn't what they write down for a legal description. Your legal description, your ownership, your property is a map done by a surveyor. X marks the spot. This is what we're talking about, right? All closed in. They got the acreage. They got all the easements. They have whatever. That is really the deed to your property is a map. And, as long as your name is on it, then that's good. What you're going to get is you have a buy-sell agreement and that has its information on that is different than the warranty deed that's been recorded, but the buy-sell agreement hasn't been recorded, and by your state's laws, it should have been recorded. Now, the appraisal doesn't have to be recorded, from what I have read, but it's still been done by a state officer, so you might want to have it recorded. In either case, you want to take it to the court if you were in a foreclosure and get a declaratory judgment. So this would be evidence to using it to get a declaratory judgment. That's what I'm trying to say. Based on these simple steps, without getting too deep into exactly how to do it yet, this is all just, here's the concept, and I'll try it over the next week or so. If I ever figure out how to do it, I'll just tell you, well, this is how I did it, and you can do it the same way. But if you want to go try it on your own, well, here's what you're looking for. Some way to put in a declaratory judgment on something like a deed, right? And give them a copy of what you wanted to make a determination on, and have the rights and status and so forth all adjudicated by a judge. And so if you're in a foreclosure and then the judge says, well, yeah, what you gave me is correct and what they're using isn't, then what they're doing in court is a malicious prosecution. And now you can get additional relief from the judge in the form of having your rights, titles, and interests established, and getting paid the cost and attorney's fees. And, well, in fact, they cover that in here, right? Award of cost. In any proceeding under this article, the court may make such award of cost as may seem equitable and just. Further relief based on a declaratory judgment may be granted whenever necessary or proper. Right? They're just telling you how they're going to do it. So, or what they can do. I mean, it's pretty liberally construed. We just have to ask properly. Right? The application, therefore, shall be by petition to a court having jurisdiction to grant relief. Right? How to say to do it? By petition. What's a petition? It's a civil action. All civil actions are petitions. The application, therefore, shall be by petition to a court having jurisdiction to grant relief. If the application is deemed sufficient, the court shall, on reasonable notice, require any adverse party whose rights have been adjudicated by the declaratory judgment to show cause why further relief should not be granted forthwith. Because in the court case, in your foreclosure, they're claiming like the securities and the note that's been converted to a bank note, and now it's actually, book entry money that could very easily be converted to legal tender and paid to the proper owner, which is you. We just haven't claimed it yet. And so the idea is, hey, using the idea of the declaratory judgment, what can we do? So I wanted to see what I could do. I said, well, I wonder if I put one in my court case, what to do with it. And so, now you can, oh, by the way, you can file these online yourself, right? If you go to the United States Court of Appeals for Veterans Claims, and you go down here to docket search, and you put in 19-1910, hey, you'll be watching, live what's happening in this court case. If you searched under just Ritluski, which it allows you to do when you do a docket search, you can put in the party. Well, if you did that instead, then you would see I have more than one case going on. Right now, we're looking at this one. And this one, that is sad, this is what I put in, that I'm asking for. All right, the United States Court of Appeals for Veterans Claims, Robert Allen Ritluski, he'd be the petitioner, versus Robert Leon Wilkie. Secretary of Veterans Affairs, respondent. Now, they'd like to shorten that to Robert A. Ritluski versus Robert L. Wilkie, but, I know who it is. Motion for declaratory judgment. Cause of action, 28 U.S.C. 2201, creation of a remedy. Request for declaratory judgment to determine if a disabled veteran can secure and retain substantial gainful employment as defined by the United States Department of Veterans Affairs, VA. This is how they define it on the VA's own documents. Substantially gainful employment. Substantially gainful employment is employment that is ordinarily followed by the non-disabled to earn their livelihood with earnings common to the particular occupation in the community where the veteran resides. It comes out of their manual M21-1M, Part V, so Part 2, Chapter 1, Section B, a long-ass manual. But in there, they defined what it is, and they said, ordinarily followed by the non-disabled. Well, I'm a disabled vet, so I can't, I don't fulfill the definition of substantially gainful employment because I'm not non-disabled. So petitioner asked this court to provide legal certainty if a veteran acknowledged as disabled by the United States Department of Veterans Affairs can secure and retain substantially gainful employment when such employment is defined by the VA as employment followed by non-disabled persons. And, hey, they were nice enough to put it on the docket. So now, right, it's gone to the parties involved, and they have so many days to answer the motion, and, well, let's get it on and get it decided. So this just came on today, right? Sometime this morning. I was actually sending them another one about this, invoking Rule 2. In fact, I'll show that one in just a second. And asking a little bit more clear what I wanted, because this hadn't shown up yet, and I had put it in on Friday, and, well, it was some days ago. Today's Wednesday. It's like, oh, maybe they didn't like that one. Maybe I hadn't followed a rule, so I changed it a bit to follow a rule. But as it turns out, they put it on. And now I'll see if they put the other one on. And so I have two other things that are going on. I'm going to get to those right now, so give me a second to load those up. Okay, so like I said, was writing this, sent it in, checked my email, saw that the one I had put in on Friday had shown up today, finally online. But, I did it a second time. So in this way I said, United States Court of Appeals for Veterans Claims, Rule 2, Suspension of Rules. Which it says, I should have shown that here. Rules. It says in the rules, because I'm sure it says this in lots of courts, right? This is why I'm showing this. This isn't just for this veterans court, like this would be the only court that would have this. Now, we just need to maybe read things a little bit different. So Rule 2 is suspension of rules. On its own initiative or on a party's motion, the court may suspend any provision of these rules and otherwise order proceedings as it sees fit. Well, that fits me much better than trying to follow a bunch of fucking rules, man. I like to bend them a bit, work around them. I'm not looking to follow the rule. I mean, I know what they are and I know how to use them to my advantage, but that doesn't mean I want to follow them. Cheapers. I want to use them. And this one says I can invoke this rule to say, cancel the other rules and let's just go ahead and do it as we see fit. Well, I think it's fit that they give me a frickin' remedy. All right, so cancel the rules. Petitioner request a suspension of rules by this court in case number 19-1910 and its creation of a remedy by declaratory judgment in accordance with 28 U.S.C. 2201 concerning the ability of a veteran with acknowledged disability to secure and maintain substantially gainful employment, as this phrase is currently defined by the United States Department of Veterans Affairs in that long-ass MR number, where it says the phrase substantially gainful employment is defined as employment that is ordinarily followed by the non-disabled to earn their livelihood with earnings common to the particular occupation in the community where the veteran resides. If I'm disabled, I can't be non-disabled. I don't fit. It is the petitioner's belief that the use of plain language interpretation, only non-disabled individuals can secure and maintain substantially gainful employment as defined by the VA. Further relief under 28 U.S.C. 2202. If the court's declaratory judgment confirms that a disabled veteran cannot secure and maintain non-disabled employment, then the petitioner requests his unemployability be established for pension purposes without further delay. Respectfully submitted. And if you didn't know, I didn't know this until I started looking at this court's rule book closely, that to do a electronic signature, you got to put the S and the slashes and then put your name after it. And a lot of times when I see documents that have been submitted into people's court cases by attorneys and so forth, they got the slash with the S, but there's no name after it, which really means they didn't sign the damn thing. Another one of the little tricks they do. So this was my second attempt at the same thing that had already been filed into this court case, but, well, we'll see what happens. And that's that court case. And then I had the other one going on, or still have it going on with, all right, this is 1927-28, which which nothing has happened since they put in the notice of docketing for a petition for extraordinary relief, in which I'm asking the American Legion to get itself squared away, get properly registered, so that veterans can use it as a tool, because we're supposed to be upholding and defending the Constitution. And if the American Legion was properly formed right now, we would have the authority to do so, because it can sue and be sued in the courts of the United States. And then I wouldn't have to do this myself and try to figure out how to do a court case. I just put a demand in to the American Legion and demand they go put in a court case. And they have an advocate general, or what do they call it? The judge advocate general? I believe that's what his name was. So one last thing then. I brought up this thing to start with. Well, you cannot impeach an impostor. Maybe you can have them declared one. And I've shown in many videos in the past that there isn't anybody in Congress that has a proper oath of office. Right? If you didn't subscribe your name, fill the form out, do everything that you're supposed to using your full legal name, then it's not legal. You need to use your full legal name. So since they didn't, well, they're really not holding the office. They're just pretending to. Right? So I'm going to see if I can have one of these imposters declared one, and well, then we'll see what they have to say from there. And I did that in the same court. United States Court of Appeals for Veterans Claims, where Robert Allen Rytlewski, this time he didn't pick, the Secretary of the VA to be the respondent, and I didn't pick the American Legion to be the respondent. I picked the Chief Judge of the United States Court of Appeals for Veterans Claims to be the respondent, Robert N. Davis, Chief Judge. In which I said the United States, in the name of its relator, petitions for extraordinary relief. Right? Because I am the relator of the United States. The United States is the sovereign, but it can't speak. I'm its speaker. And I'm saying you're violating the laws of the United States, and the United States wants something done about it. Right? They didn't do it to me. Right? This isn't a private issue. This is a public issue. This is public rights have been violated. And in Old English law, that's how it worked. The king had the duty to enforce his law, or why else would he be the king and have the damn law? You could be made an accessory because you didn't tell the king that somebody was breaking his law. Right? Well, now they call that misprison. So let's use that to our advantage. Let's go to a federal court and make them aware of laws being broken and tell them to be a misprison, not to do something about it. So what did I do? I said this, hey, relief sought. I wanted an inquiry into the constitutionality of the oath of office filed by Nancy Patricia Pelosi as member-elect to the United States House of Representatives. If oath is determined unconstitutional, then for Chief Judge Robert N. Davis to arrest Nancy Patricia Pelosi in accordance with 18 U.S.C. 3041 powers of courts and magistrates for her impersonation of an officer or employee of the United States. And they actually have a law against that. Go figure. All right. 18 U.S.C. 912, officer or employee of the United States, in which it says, whoever falsely assumes or pretends to be an officer or employee acting under the authority of the United States or any department, agency, or officer thereof, and acts as such, or in such pretended character, demands or obtains any money, be like a salary, paper, document, or thing of value, shall be fined under this title or imprisoned not more than 3 years, or both. One thing's for sure, they would be leaving the office that they're pretending to hold. And I'll take that to be enough for today. So what's the facts necessary to understand the issue? Because I'm only picking on Nancy Patricia Pelosi because she's the Speaker of the House. Whoever the Speaker of the House was going to get this. She's up. She gets it first. But this applies to any member of the House. It applies to any member of the Senate. It probably applies to Donald J. Trump. Until he becomes Donald John Trump, he's just pretended to hold the office. But, Nancy Patricia Pelosi falsely assumes to be representing California's 12th District as a member of the United States House of Representatives, using an assumed name to conceal her identity. Nancy Patricia Pelosi falsely certified her name as Pelosi, Nancy, on a statement of candidacy, that'd be your FEC Form 2, under candidate's FEC identification number, H8CA 05035. Now, why is that an 8? You think it'd be H12 if that's the district she's in. But no, it's H8CA 05035. I didn't say it. It's on her frickin' form. Nancy Patricia Pelosi has not recited, subscribed, and filed the oath of office to support the Constitution as required by the 6th Article of the Constitution of the United States. The proper oath of office to support the Constitution is mandated in statutes at large at 1 Stat 23, an act to regulate the time and manner of administering certain oaths. Nancy Patricia Pelosi concealed her full legal name on the counterfeit oath she subscribed and instead used the pseudonym Nancy Pelosi on her filed unconstitutional false statement. She didn't file an oath of office. She filed an unconstitutional false statement. Or you could say it's a counterfeit oath of office. Nevertheless, 5 U.S.C. 3331, which is the oath all these people claim to be taking, contains a religious test and thus conveys no authority under the United States, because in the 6th Article of the Constitution, it says the oath can't have any religious tests associated with it. And I'm afraid saying so help me God, although I'm happy to say it because I do, well, that's a religious test. Nancy Patricia Pelosi collects a salary. Yes, she does. From a United States office she is not qualified to hold. Yeah, I think that'd be a violation of 18 U.S.C. 912. Nancy Patricia Pelosi counterfeited a public security of the United States. That would be an oath of office. In the offense of an act for the punishment of certain crimes against the United States, commonly known as the Crimes Act of 1790, and filed the same with the clerk of the United States House of Representatives. Nancy Patricia Pelosi provides aid and comfort to enemies of the United States by obstructing the justice owed the United States by its duly elected and appointed officers. Reasons why the court should grant the petition. Well, you got the Constitution of the United States, you got 18 U.S.C. 912, you got 28 U.S.C. 453, which is the oath that the judge took. You got 18 U.S.C. 004, would tell you it would be a misprision of felony not to do something about it, right? It would have been a misprision of felony not for me not to have told an officer of the United States about what's going on. And that's the same with 18 U.S.C. 2382, except now it's misprision of treason. 18 U.S.C. 1001, that'd be those false statements, right? Where in that law says an omission of a material fact is a false statement, as is a false statement. But to omit a material fact, is a false statement. Then you got 28 U.S.C. 2201 and 2202, my two favorite statutes now. Creation of remedy, which will give you the declaratory judgment, and further relief. Well, now that we have it decided, right, who gets the property? Nancy Patricia Pelosi appears to be an enemy of the United States. Having been so informed, it is the Chief Judge's duty to inquire into her usurpation and arrest her if evidence affirms her guilt. And what kind of information did I give them? Well, I didn't think it would take much. I'll give them a copy of the form that I talked about. And then the congressional record where it shows they're taking the improper oath of office. So any candidate that ran filled out this form. It's an FEC Form 2. That'd be the Federal Election Commission Form 2, Statement of Candidacy. All right, and right off of the bat, name of candidate, Pelosi, comma, Nancy, comma, comma, comma. That's not your name, sister. It ain't working, right? It said name of candidate in full. I want a declaratory judgment if that's Nancy's name or not. If not, then she didn't fill the form out right. All right. Address. This is actually the Russ building. It isn't her home address. This is like downtown San Francisco. H8CA05035. Why isn't that H12? House 12. Right? Party affiliation, Democratic Party. Office sought, House. She wants the whole thing, right? She don't want some office. All right, and then she got a couple of things here where she's asking for money, and then signature of candidate. Pelosi, comma, Nancy, comma, comma, comma. No, I don't believe that's going to work, Nancy. And then in the congressional record, this had been for January 17, 2019, where it was said, after an absence, or excuse me, after adjournment, right? So the House is adjourned for the day, and now they're going to act like they're putting all these oaths of office into the record. It says they're going to take the oath of office in 5 U.S.C. 3331, which says IAB, right? So I, full legal name, you solemnly swear, because that is your identification, and you only have one of those for official purposes. And if this isn't official, then nothing is. So I say it's official. And when I took my oath of office, I had to use my full legal name. Right? So I'm not taking orders from anybody who didn't use a full legal name in their oath of office. Right? You're not from my venue. In fact, you're an enemy of my venue. You're going to have to leave. So help me God. There you go, sister. There's that religious test. I'm afraid this is an unconstitutional oath that Nancy Pelosi said that she took. Right? But Nancy Pelosi isn't her full legal name. It's Nancy Patricia Pelosi. And so I filed those papers with a declaration of financial hardship, which I wanted to show this because shows you how much easier it is than to do the pauper paperwork they want you to do at district court. Right? I am the petitioner. I declare by my signature below the payment of $50 filing fee required by these rules, so the court's rules of practice and procedure, would be a financial hardship for me. Yes, it would. So pursuant to 28 U.S.C. 1746, I certify under penalty of perjury that the foregoing is true and correct. Now, if you ever go to that section, 28 U.S.C. 1746, you'll see there's actually two certifications. One in the United States, one within, one without. This is the within. Right? I don't want to be taken to the United States of America, which is where the other one applies. I'm within the United States. That's just my statement. And there's that rule 2, right? Supervision rules, or suspension rules. So I have to think in any court's rules of civil procedure, any kind of procedure will be somewhere they can suspend the rules, right? So that was what my motion was based on the second time around, right? Let's suspend the rules. I know I want a declaratory judgment. And, I'm trying to eliminate the jots and tittles of the law that I need to do precisely correct or I don't get a remedy, right? Because it's the, devil's in the details. So get the devil out of the way. I don't want to have to deal with all that. I don't want to have to do the court case. I want to tell them and have them do the court case, right? They're the experts. So, I'm not looking at them to judge me. I'm looking to use them as a tool, right? Go get this done for me. Right here in this case, determine for me that I can't ever be substantially gainfully employed. And if you do, well, then get me my unemployability. And in the meantime, I'm not putting up with these people in D.C. anymore or anyplace else. And so let's pick one. Well, I picked Nancy, Patricia Pelosi. And I want you to inquire into the constitutionality of her oath of office. Right? It's filed with the clerk of the House of Representatives. Go take a look at it. If it's not constitutional, in other words, if it's unconstitutional, then arrest her damn ass. Now, I could have put the whole group of them in there, right? But you people are smart enough, right? Just follow the string. I'm sure just as soon as you arrest her, she'll start telling you that none of these other people have it. She'll be naming them off for you. Right? Just turn the tape machine on. Start taping. Anyways, that's been filed. And so what I'm waiting for now, right, all that for this, right, will I get a third entry here? Right? Will there be another case added? For me against the well, I don't want to say versus. I hate to use that term, but hey, they're the ones that come up with this crap, not me. Right? I'm not versing Robert N. Davis. I'm using Robert N. Davis to his, potential. Chief Judge, here, let's go issue some arrest warrants. Let's clean out the riffraff. Let's us drain the swamp. We don't need to wait. I'm a veteran, for God's sakes, right? If no one else will do it, I will. I don't have any problem giving orders. So that's where we're at. We'll see what happens next. But, gotta, what else are you going to do with your life? Have a great day. We'll see you.